Okay, good afternoon, everyone. So, let us start the class today. So, yesterday we have learned a lot about contract of agencies and also Sale of Goods Act and Sale of Goods Act Part Two, negotiable instruments, and also about partnership. Okay, so after that we'll move on to the next block, which is Companies Act 2013. So, in this, we'll okay. So, the company is a fictitious entity endowed with jurisdicts personality. In a sense, a company is an artificial personality. Okay, in a sense, company is a artificial legal entity. Okay, and the Joint Stock Company Act 1844 has bestowed legally counter to concept of company. The first Companies Act was passed in India in 1950 on the lines of English law. In a sense, when I think you may have know that during the mid 18 44 to 1850s, there was a trade through uh, East India Company, which entered India, I mean, a long time ago. So, based on that, the law also uh, has its origin from the English laws. So, Joint Stock Companies Act 1844 has bestowed legal counter to concept of company. The first Companies Act was passed in India in 1850 in the lines of English law. Since then, it has been modified from time to time. The Companies Act 1956 has been thoroughly amended on 8th August 2013 and notified in the official gazette of 30th August 2013. So today, for all practical purposes, we shall go for this amended act, okay, which is Companies Act 2013. So let's see what are the objectives of the Companies Act 2013. In a sense, it is in order to promote and develop of a economy by encouraging entrepreneurship and enterprise efficiently. Okay, in order to promote the development of the economy and encourage entrepreneurship and enterprise efficiently, and also to encourage transparency and high standards of corporate governance. Okay, on the basis of these things, the Companies Act 2013 has been amended. Okay, for the Companies Act 2000, 1956, I think you have all studied about Companies Act 1956. So, based on that, after the amendment in 2013, this act has been brought to life. Okay, so and it is for the to provide for the incorporation, categorization, management, and administration of different types of companies. Okay, and also to accommodate for mergers, amalgamations, and takeovers, and also for registration of foreign companies doing business. Okay, and also cooperatives to operate under the style of companies. Okay, so so also cooperatives can operate in with the as per the uh, like a company. Okay, and color coding of certificates of incorporation, all these things will be initiated, and incorporate financial reporting provisions, responsibility of public company, startup and functioning of small companies, and provide for matters connecting with or incidental to the foregoing of the company. Okay, and the effect. So the definition of company, in a sense, a company means a company formed and registered under the Companies Act 1956, or an existing company as defined in Clause 2 of the Act, Section 3, 1I, Companies Act 1956. So uh, this is the basis for that, and the types of companies, in a sense, we have several types of companies. We can be it can be broadly classified into like private company, public company, and producer company. However, it may also further be classified, categorized as under on the basis of nature of incorporation, on the basis of liability, on the basis of intercompany relationships, on the basis of listing in the stock exchange, on the basis of nationality, and uh, also the government companies. So we can categorize the companies like this. Okay. In this, on the basis of nature of incorporation, in a sense, chartered company, which is created by grant of charter, and statutory company, it's constituted under the Act of the Parliament. Sometimes the Parliament, state legislature, uh, form companies which are statutory companies. For example, LIC and all comes under that, and registered companies, registered under the Companies Act 1956. Next is a registered company, which is comes under the Companies Act 1956. As per the guidelines and regulations based on the Companies Act, which is registered, are called a registered company. They are that is the on the basis of nature of the incorporation, and on the basis of liability, if we see, unlimited company and unlimited company is there, and company limited by guarantee is there. Unlimited company is where the liability of the members towards the debt of the company is unlimited and will be in proportion to their interest in the company. As much as interest they hold in a company, based on that, their liability will be uh, unlimited. In a sense, they will not be, I mean, they will be liable for everything. If in case of any loss, or in case the company is winding up, all their property will be liable in that case. And where that is called unlimited company. And whereas company limited by guarantee, the liability of the member shall be limited to the amount as the members may undertaken, by the memorandum, to contribute to asset, limited by guarantee, in a sense, where they have certain limitations. Okay, it only applicable to the extent of what they have undertaken in the memorandum to contribute to the assets of the company. Even if the event of winding up also, they are only liable to the only that much. Okay, and next one is company limited by shares. Company limited by shares, in a sense, the liability of the membership shall be limited by the memorandum of the amount. Okay, if any unpaid on the shares held by them. Okay, only it will be limited up to the share price. Okay, only up to share price they are liable, not more than the price, I mean, shares they hold in a company. Okay, they will only be liable in case if they have not paid the shares completely. If they have not paid for that, only they'll be liable for the unpaid uh, part of the shares. Okay, next one is on the basis of intercompany relationships. So intercompany relationships, in a sense, holding company and subsidiary company. It can be classified into holding company and subsidiary company. Whereas holding company, which holds certain rights on another company, and subsidiary company is also a part of the same company, or a bigger company. Okay, uh, under its name, subsidiaries will be working. Okay, and on the basis of listing in the stock exchange, so there are listed companies and unlisted companies. On the basis of listing of stock exchange, which is listed in the stock exchange and which are not listed. Okay, which are not subscribed. And on the basis of nationality, there are Indian companies and foreign companies. I think you know the basic difference of that. So next is government companies. Government companies, in a sense, where the government holds a part of shares, in a sense, where part of shares is more than 51% of the shares will be uh, owned by the government. Okay, 51% is the uh, minimum limit for in the shares. And it could be partly by the central government and partly by one or more state government also. Okay, a subsidiary of government company is also treated as a government company. Okay, and next one is incorporation of company, whereas the promoter takes initiative for the uh, formation of the company. Promoter, in a sense, the person who comes with the idea to start the company initially. He's known as promoter. Okay, so the promoter takes initiative for the formation of company. He picks at least five names on the basis of priority, suitable names, and apply for availability of names with the registrar of the company. Okay, if the names what he has picked, whether it is available for the name the company, so that he will check first, and no company can be registered with the same name, which is and also which is undesirable or which is identical with or too nearly resembles the name of an existing company according to section 20 Companies Act 1956, and such name which is prohibited under the emblems and names, the government emblems, all those things cannot be generally used by a new company. I mean, all these things will is matters, when picking the right name for the new company. Okay, and prevention of improper use of this under 1950. Okay, and on obtaining approval of name, the promoter shall submit e-filing application enclosing uh, necessary documents prescribed for registration of company, along with memorandum of association and articles of association to the registrar of companies (ROC). Uh, so, registrar of the company to whom all these documents has to be submitted. Okay, so he's the one who issues the incorporation letter. Okay, that I will explain a bit more in detail in the further time. Okay, so these are constitutional documents of the company, which are memorandum of association and articles of association. Okay, it's also a memorandum and article. These are the main or constitutional documents of the company for registration and administration purposes. Okay, not only for registration purpose but also for the administration of the company. These are the main documents. Okay, and it is in edific on which the structure of the company is based. Okay, the entire structure of the company is based on these two. Okay, it defines the scope of the company's activities and its relations with the outside world. Okay, it defines the scope of the company's activities. What are all the activities are allowed for the company, what is its powers, what are its rights and liabilities. So all these things will be covered inside in the content of the memorandum of association and articles of association. Okay, so this uh, that's how it will interact with the outside world. Okay, so let us see what are the contents of the memorandum of association. So there are certain clause to it. For the example, these are certain clause which are the contents. Okay, so name clause, situation clause, object clause, liability clause, capital clause, subscription clause. Okay, subscription to the shares, and there is also some remedies available for in case of if all these things needs to be altered, in the time, uh, in the future, if they want to make some changes or make some alterations, there are certain remedies available to it. So name clause, name I have already told you that uh, the company being a legal entity shall have a name of its own. Okay, it should not be resembling another company's name. All these things will matter. Okay, and with respect to whether the company, if it is a limited company, in the case of public limited company, and it has to uh, add limited. Okay, it has to add limited, word limited in front of it. And if in case of private limited company, the last words in case of private limited is the they should have private limited. Okay, according to the section 20 in New Companies Act 2013. Okay, and Um and availability of name may be ascertained from the website. Okay, there is a website, www.mca.gov.in. Okay, this is a with respect to, they can check the availability of the names. In case if they don't know whether they can choose a particular name or not for the people who wants to start a new company, they can check there in the mca.gov.in. Okay, once the name is approved, such name will be reserved for the use for the proposed company. Okay, that name will be reserved for the period of 60 days. Okay, that name will be reserved for 60 days, and the name and address of the registered office of the company must be printed or affixed outside every office or place of business in a conspicuous part. The name and address of the company has to be put in place outside their offices. And there are it can also be altered in case if the company, the name needs to be changed. So there are certain procedure for that. When the name is incidental with or too closely resembles the name of another existing company, or where company decides to change its name, or in that case they have to, registrar will enter the new name in his register and issue a fresh certificate of incorporation. You know, but in either case, the company before moving for registration shall get clearance from the board, and the government also, they have to get clearance from them when they want to make these changes. Okay, to the uh, name clause, when they want to alter the name. The next one is situation clause. Situation clause, in a sense, the name of the state in which the registered office of the company is to be situated, where the company will be situated. That is situation clause, where the company will be situated. Okay, the name shall be notified to the registrar of companies (ROC) within 30 days from the date of incorporation. Okay, the where they want to locate the office, where they want to start the office, that location has to be uh, notified to the registrar of companies (ROC) within 30 days from the date of incorporation. Okay, the location of the registered office of the company may be changed from time to time. It can be changed. The location can also be changed within the state, and without amending the registered office clause. Okay, without amending the registered office clause, they can also change the uh, location of the company within the state. And there is also certain procedure for the alteration of the situation clause. One place to another place in the same city, they can move into the same city, town, or village, from one place to another place. Okay, change within the local limits of the same town, they can move. Okay, and also city, town, or village on another city also they can move. And also jurisdiction of one registrar of companies to the jurisdiction of another registrar of companies within the same state, with the prior confirmation of the regional directors. Okay, they can move from one jurisdiction of the ROC to another jurisdiction, another ROC. Okay, and also from city or town, village, one in one state to another city, town, village in another state also they can move with the prior confirmation of companies law board. Okay, as per section 17A 146 Companies Act 2013. Okay, next one is object clause. Object clause, in a sense, every company shall have the object clause in its memorandum of association, which includes the main object of the company to be pursued by the company on its incorporation. For what purpose the company is will be they are starting, that has to be clearly mentioned in the MOA. Okay, the object incidental or ancillary to the attainment of the main object, or other objects of the company not included in subclause in the case of companies other than trading companies with objects not uh, confined to one state. Okay, so the thing is that it has to mention for what purpose they are starting the company. Okay, that is the object clause, and it it affirmatively determines the ambit and extent of powers of the company. Okay, um, it also restricts the powers of the company to those which are reasonably necessary or incidental to the object pursued by the company. Okay, any activity which is outside the limits so set out has no legal validity. In case if they and the act beyond this ambit or ultra wires and hence void. If they operate beyond the scope of it, it will be void and or called ultra wires. Okay, and that can also be altered as per the law, and alteration can be made in a sense. When they want to carry on its business more efficiently and economically, and attain its main purpose by new or improved means, enlarge or change the local area of its operation. So in these cases it can make alteration with the object clause. And when they want to carry conveniently or advantageously. Okay, and also restrict or abandon any of the objects specified in the memorandum. When they want to restrict or abandon any previous or old objectives, they can also make the alterations. And in case of okay, so these are the some of the basic things what will be included. And liability clause, next one is liability clause. In a sense, the clause indicates the nature and extent of liability of members, what the members of the company are liable to, limited or unlimited. If it is limited, then whether it is limited by shares or by guarantee, that will be considered. And in case of companies limited by shares, no member can be called upon to pay more than what remains unpaid. The call on the shares, what I'll also explain later in the next unit when we learn about shares. Okay, I hope we have enough time for everything. So let's see. So um, this is with the liability clause, and next is capital clause. Okay, capital clause, in a sense, the amount of the share capital, okay, which the company raises or okay, so it's in the whether it is equity shares or preference shares of shares of the fixed amount. Okay, the shares into which the capital is divided must be of fixed value, and which is commonly known as the nominal value of the shares. Okay, the how they will be dividing the capital on a okay, capital is divided must be of fixed value. Okay, which is known as the nominal value of the shares. If the company is intending to issue more than one class of shares, the capital clause must divide the authorized capital into shares of different classes. Okay, and fixes the nominal value of each class. In case if they want to divide the authorized capital into shares of different classes, the fixed and fixes the nominal value of each class they have to fix. Okay, the amount of nominal capital is determined having regards to the present as well as future requirement of the company with reference to its objects. Okay, company is not authorized to issue capital beyond its authorized nominal or registered capital. They are not allowed to issue uh, and raise capital beyond what is authorized. Okay, and next one is alteration to okay, capital clause. I mean, it can also be altered with respect to the provisions provided in the law. And also next one is subscription clause. Subscription clause, in a sense, each subscriber shall sign the memorandum of association specifying his address, description, and occupation, and shall also specify opposite to his name, number of shares, and he proposes to subscribe. Okay, no subscribers can take less than one share. Okay, in New Companies Act 2013, they are not supposed to take less than one share. Okay, and they should provide the name, address, description, occupation, and all these details provided, in proper way, and each subscriber shall sign the memorandum of association. Okay, and so that's with the those are the contents included in the memorandum of association. And the next one is doctrine of ultra wires, in a sense where I mean any commission or omission contrary to the object clause of the memorandum of association is prohibited. Okay, in case if anything is contrary to the what is contrary to the object clause of the memorandum of association is prohibited. Neither the company nor any other person shall go against it. Okay, any such act would be treated as ultra vires. Okay, if anyone trying to go against even the company or any member of the company is trying to go against it, uh, it will be treated as ultra vires. This not binding upon the company, so company will not be binding. Okay, and consequently, either the company or the other, in case if there is any defect, even the outside third part, if any defect from the company side, company member side, the consequently either the company or the other contracting party sue can sue on it. Okay, and it is void ab initio. The ultraviolet acts are null and because of that they are void ab initio. Okay, ultraviolets are null. Okay, so let's focus on articles of association now. So the articles of association of a company. uh, Okay, actually, article means the article of association of a company as originally framed or as altered from time to time in pursuance of any previous company law or of this act. Okay, so the article of association or its bylaws or rules and regulation that govern the management of its internal affairs and the conduct of its business. In a sense, memorandum of association, it will be providing the guidance and required legal uh, documents for operation, outside, whereas articles of association also, internal affairs and all this will be for internal management and management of its internal affairs. Articles of association provide the basis, okay, to conduct its business. uh, and the articles play a very important role in the affairs of a company. It deals with the rights of the members of the company, what are the rights the members have, and they are and their subordinates to any. And actually, articles of association is a kind of a subordinate to memorandum of association. Okay, thus actually the memorandum of association lays down the scope and powers of the company, and the articles of association governs the ways in which the objects of the company are to be carried out. Okay, whereas memorandum of association lays down the scope and power of the company, article governs the ways in which objects of the company are to be carried out. Okay, how they can be carried out, how it can be functioned, that's what it guides. Okay, and how it can be framed and altered by the members. Okay, must keep within the limit marked out. It has to be within the markings of the memorandum of association. Okay, and also on the point of view of the Companies Act, it should be within that. Okay, and it must be printed, divided into paragraphs, numbered, and stamped adequately, and signed by each subscriber to the memorandum of association, and duly witnessed and filed along with the memorandum of association. So that's what articles of association also be filed along with the memorandum of association of the company. The articles must not contain anything illegal or ultra wires to the memorandum of association. It shouldn't contain anything illegal or anything void or in contrary to the memorandum of association, nor should it be contrary to the provisions of the Companies Act 2013 and also the previous 1956 Act. Okay, and it can also be altered. Okay, and there are alteration can also be done with the with reference to articles of association. Okay, when uh, alteration must not exceed the powers bestowed by the MOA, but it shouldn't exceed the powers bestowed by MOA, and not to I mean, not be inconsistent with any provisions of the Companies Act or any other statute. Okay, and also shouldn't be illegal or opposed to public policy and must be bona fide for the benefit of the company. Okay, alteration must not constitute a fraud on the minority by a majority. It shouldn't constitute any fraud on the minority by the majority. Okay, all those things should be kept in mind before the alteration or any such thing is allowed. Okay, public company into a private company cannot be made without the approval of the central government. Okay, without the approval of the central government, a company cannot be converted into a private company. Okay, so there are many rules to it. So let's focus on certificate of incorporation. Whereas the register of company, if satisfied, he will. I already told you that register of the company, who will be under the regional directors, or maybe one. They are the concerned authorities who issues the certificate of incorporation. Okay, if and they will issue it in case if satisfied that all the requirements for incorporation is completed, which shall uh, with that they will certify under his hand that the company is incorporated. Okay, this certificate is known as certificate of incorporation, and the certificate is not only the proof of the company's birth but also its legitimate birth. So it will be considered as the birth of the company when uh, they will receive the promoter of the company and the members of the company receive the certificate of incorporation. So let's see who is a promoter. The promoter is a person uh, who starts this business. Okay, it's initially his idea and or who starts the business or plans to acquire a existing business. Okay, so he's the person who initiates. He's also called as founder or organizing the who is responsible for organizing the business enterprise. Okay, he undertakes to form a company with reference to a given object and to set it going to accomplish the said purpose. Okay, he decides the scope of company's business activity, negotiate, and if necessary for the purchase of the existing business. Okay, and instructs the solicitors to prepare the necessary documents and secure the service of directors, and he makes needful arrangement for mobilizing capital and advertising and circulating the prospectus. Apart from taking steps for its registration, he does all these things. Okay, the promoter means a person who has been named as such in the prospectus or is identified by the company in the annual return referred to in section 92. Okay, or who has control over the affairs of the company directly or indirectly, whether as a shareholder, director, or otherwise, in accordance with whose advice, direction, or instruction the board of directors of the company is accustomed to act. Okay, so as per section 269 Companies Act 2013, regulation 2, SEBI, so these things are uh, considered as promoter. Okay, to be a promoter as per the law. So next thing is we'll see what is a prospectus. So prospectus means any document described or issued as a prospectus and includes any notice, circular advertisement, or other documents inviting deposit from the public. Okay, this is an invitation to offer, make an offer to the public, and the public will be offering the money in return for capital for purchasing of the shares. Okay, from the public, or inviting offer from the public for the subscription or purchase of any shares in or debentures of a body corporate. This document is said to be prospectus when there is an invitation to the public, and invitation is made by or on behalf of the company or in relation to an intended company. Okay, the invitation is made to subscribe or purchase. The invitation is related to share or debenture or other instruments. Okay, any advertisement offering shares or debentures of the company for sale to the public is a prospectus. Okay, any advertisement offering shares or debentures of the company for sale to the public is a prospectus. Okay, so there are several content of prospectus, in a sense the prospectus must be dated, and a copy of prospectus must be filed with the registrar uh, on or before its publication. Okay, before or on the date or before it's published, it has to be filed under the registrar. Okay, ROC, registrar of companies. Okay, and there are several documents need to be uh, attached and submitted. Okay, along with the prospectus for filing with the registrar. Okay, so let's move on to the next unit, share capital. The term capital has a variety of meanings. It may mean one thing to an economist, and one to an accountant, while another to a businessman or a lawyer. A lawman views capital as the money which a company has raised by issue of its shares. It uses this money to meet its requirements by way of acquiring business premises and stock in trade, which are called the fixed capital and the circulating capital, respectively. Okay, okay, so the share capital, it is synonymous with the term capital, and the memorandum must state the amount of capital and its division into various types. Okay, number and value of shares. Okay, it has to be, you know, uh, and let's see what are the kinds of shares. Okay, there are equity shares and preference shares, and equity share capital with voting rights and without the with differential rights as to uh, dividend. Okay, where voting or otherwise, whether that will also be there. That will I'll explain in a short while. And preference shares, along with the preference share capital as per section 43, 86, 88 Companies Act 2013. So what is equity capital? In equity cap share capital as one which is not uh, the one which is not a preference share capital. Equity share capital is the most common form of capital issued by the company to raise funds, okay, from the public, because of the following reasons. It is risk capital around which entire investment is built. It ensures protection to creditors as it cannot be repaid easily. Okay, it enhances the bargaining capacity of companies. It does not carry any fixed rate of return. Holder of share will get share in profit and stock market value uh, at multiple of its earnings. Okay, you know that shares multiply in values, so that's what it offers to the holder. Okay, it does not carry any fixed rate of return. Based on the profit, the share they'll be getting the dividends. Okay, no return need to be paid in case of loss. In case of loss, the company don't have to pay any returns. Okay, if the company is not making any profit, they are not obliged to uh, pay. pay the dividend to the shareholders. Okay, and so, what are preference shares or preference share capital? The preference shares or preference share capital is that part of the share capital which fulfills both the following requirements. In a sense, I'll explain you that with respect to dividend, it carries a preferential right to be paid. Okay, the preference share capital, where preference shareholders will be get a preferential right to be paid a fixed amount or amount calculated at a fixed rate, which may be either tax, with the tax or a tax free. Okay, with respect to capital, it carries on winding up or repayment of capital. On winding up they will get repayment of capital, whereas earlier equity share capital holders, they will be not getting it, whereas preference share capital holders, they'll be getting the amount even when the company is winding up. Okay, they will get a first preference, so they will get a preferential right to be repaid the amount of the capital paid up or deemed to have been paid up, whether or not there is preferential right to the payment of either or both of the. Okay, so that's with the preference share capital, and also there are several kinds of preference share capital. There is redeemable and irredeemable preference share capital. Redeemable preference shares are those which will be redeemed by a company at the agreed time, whereas irredeemable is opposite to that, and participating and non-participating preference shares. Whereas participating preference shares are entitled to participate in the surplus profit. Okay, surplus, in case of the company is making surplus profit, they'll be participating in getting that. The non-participating preference shares will not be getting any profit remaining after the payment. Okay, after the payment of fixed dividends to preference shareholders. Okay, after the payment of all the dividends to equity shareholders and preference shareholders, if the profit is left, in that case they will be entitled to payment. Okay, and cumulative and non-cumulative preference shares. Cumulative preference shares, in a sense, in 1 year company, or if it fails to pay, it will be paying the uh, cumulative amount, cumulative in the next year. Okay, that's cumulative preference share, and non-cumulative, in a sense, where in case if the company fails to pay it this year, even the next year also, it will not pay the previous years where it made loss or which were unable to pay. Okay, so there are several modes of capital raising, by issue of security, by issue of security to the public, and by issue of security to the private placement, issue of security to the existing shareholders of the company on rights basis. Okay, on the rights basis they can give the issue the shares, among the shareholders who already have holding the shares, and also for issue of to the private placement, in a sense, where the parties will be chosen for only to a group of people or select personnel. Okay, that is private placement basis. Okay, so issue of shares, like step one will be issuing of prospectus, and I think due to the lack of time, I'll just speed up a little. I will not go explaining in depth of all these concepts. So the first step will be issue of prospectus. I told you what prospectus is, and that's how they issue, raise the money. Okay, and to receive application. Okay, and allotment of shares, and to make calls on shares. Calls on shares, in a sense, there will be first call and second call. The remaining amount left after application and allotment money. There will be amount remaining, which will not be paid by the subscribers. For that they will call, call for the payment of the money, and it should not exceed 25% of the nominal value of the shares, or at least 1 month should not be lapsed, or 14 days notice should be specified. Okay, for the call. Okay, and It can be issued either for cash or for consideration. Shares can also be issued for cash or for the consideration. And debt capital. So I think we have a very short time left. So debt capital, in a sense, it is also known as borrowed capital, is the capital that a business raises by taking out a loan. Okay, it's a loan made to a company that is normally repaid at some future date. Okay, subscribers to debt capital do not become part owners. They don't get owner of the company. They don't get part owner of the company, and but are merely creditors, and the suppliers of debt capital usually receive a contractual fixed annual percentage return on their loan. Okay, and this is known as coupon rate. Okay, the percentage return what they'll be getting on the loan. Okay, debt capital ranks higher than equity capital for the repayment of annual returns. Okay, the first preference they should return the debts. Okay, their preference will be higher. Okay, for the repayment in the annual return. Okay, when the company makes annual return, their debt should be repaid first, and this means that legally the interest on debt capital must be repaid in full before any dividends are paid to any suppliers of equity. Okay, that's with the uh, debt capital. And debentures, in a sense, debenture is a document given by a company under its seal as an evidence of debt to the holder, usually arises out of loan, and most commonly but not necessarily secured by a charge. Okay, it is a document. A debenture is a document given by a company under its seal as an evidence of a debt to the holder. Okay, and kinds of debentures are there are in the similar way redeemable debenture is there, and perpetual or irredeemable debenture is there, and registered and uh, weird debenture, and secured and unsecured or naked debenture. In a sense, secured and unsecured debenture, where the debentures are secured by a mortgage or a charge on the property of the company, whereas unsecured, in a sense, it's opposite to that. Okay, and convertible debentures are also there. Convertible debentures or convertible partly or wholly into a shares of a company after a specified time. Okay, either as a result of exercise of option or in terms of the issue. Okay, so audit and auditors, I think probably know about all these things. Audit, in a sense, for the company accounts, and also the auditor is the person who is authorized to do the auditing. Okay, and it is mandatory for every company to appoint an auditor, whether public or private company. The appointment shall be made at each annual general meeting. The auditor or auditors hold office from the conclusion of that meeting. Okay, so let's move on to the next is company governance. Okay, the company cannot act on its own. It is a fictitious entity, as I already told you. It needs people to work for it. It is a artificial legal entity. Company is an artificial legal entity, but it cannot act on its own. Though it is being treated as a person, there should be people working for it, and it needs the active participation of human beings. Thus, the management of affairs of a company is solely relying on human agency in order to enable the company to live and to achieve its objectives as enshrined in the object clause of its memorandum of association. To it is necessary to depend upon some agency known as board of directors. Okay, so the board of directors are entrusted with the uh, activity of uh, you know uh, managing the company's operations and activities. Okay, The company cannot act on its own, so they it needs board of directors for the management. And there are several types of board of directors, like inside director, outside director, professional director, nominee director, special director, executive directors, independent directors, interested directors, government directors, whole time directors, and managing directors. Okay, and so these are some of the directors. And uh, number of directors, in a sense, where every public company shall have at least three directors, and in each private company there should be at least two directors. Okay, as per the law. And articles of association of companies usually provide for the minimum and maximum number of directors for its board. Okay, so the information will provided in the articles of association. And appointment of directors, in a sense, by subscribers to the memorandum, can be appointed as director by members in general meeting. And by members in general meeting, they can appoint the director by board of directors, by central government, by third parties in if it is mentioned in the articles. Okay, and by small shareholders if the it is also mentioned in the article as per the law. Okay, they can be appointed. Okay, who assumes office from the date of incorporation of the company. Okay, and next is qualification of director. In a sense, there is no law. The Companies Act 1956 does not lay down any qualification for a person to be appointed as a director of a company. However, it mentions disqualification of directors. I mean, there is no specific qualifications mentioned to become a director, but he can be disqualified, that they have mentioned. And on the basis of, if he is incompetent, and if he's is if he is an insolvent, and if he you know if he is a convicted by a court, all these things, if he has conducted, made any offensive offense, all these things, will be considered to disqualify a director. And meeting may be generally defined as a gathering or assembly, or a gathering together of a number of persons uh, for transacting any lawful business. Okay, there must be at least two persons to constitute a meeting. Therefore, one shareholder usually cannot constitute a company meeting, even if he holds proxies for other shareholders also. However, in certain exceptional circumstances, even one person can constitute a meeting. It is to be noted that every gathering or assembly does not constitute a meeting. Okay, so there are several types of kinds of meetings, like shareholders meeting, statutory meeting, annual general meeting, which is conducted once in a year, and extraordinary general meetings. Okay, uh, class meeting of shareholders. Okay, and meeting of the debenture holders, board meeting of the board of directors, meeting of the board committees. So all these things comes under kinds of meetings. So let's move on to the takeover. Uh, so the takeover, in a sense, takeover implies acquisition of control of a company which is already registered. Okay, uh, through the purchase or exchange of shares. Okay, I think you may have already all know what is a takeover. In a sense, one company taking over another company. Maybe smaller companies taking over by bigger companies. Acquisitions. So that is the what we mean by takeover, and where the undertakings will be transferred to another company. Okay, one company will be uh, managed by the another company. Okay, whereas though the purchase or exchange of shares, through the purchase or exchange of shares, by taking over the, just like I told you in the case of government companies, where the government has to government, central government, or with collaboration with the state government, a government if it holds more than 55, 51% of the company, it's called public, government company. So in this same sense, those who which holds more shares, they'll be in the control of the managing management of the company. So takeover usually takes place when shares are acquired or purchased from the shareholders of a company at a specified price to the extent of at least controlling interest in order to gain control of that company. So takeover of management and control of a business enterprise could take place in and it could also take place in different modes like partial takeover and I'll just so those are the basic things, where the transfer of undertaking. Okay, every offer or even circular containing the terms of the scheme shall be duly approved by the board of directors of the company, and every recommendation to the member of the transferor company by its directors to accept such offers. Okay, it shall be accompanied by such information as provided under the said act. Okay, so there are transfer of undertaking from one company to another company. Okay, so with the approval of its board of directors, and every member should be properly communicated, and they are obliged to follow the recommendation. Okay, so I think I've taken a bit more. So I'll also taking the another class after from 5 to 6. So I'll explain further what is left over in that class. So thank you for your patience listening. Thank you, everyone.